Good evening, or good morning, or good afternoon, depending on in which time zone you're seeing this. And sorry for starting a few minutes late. So my name is Christophe Paulussen, and I'm the acting academic director of the T.M.C. Institute. And I would like to warmly welcome you to the last Supranational Criminal Law, or SCL Lecture of 2023, entitled Navigating the International Legal Landscape of the Israel-Palestine Conflict. The SCL Lecture series is a series on international criminal law and has been organized since 2003 by the Israel Institute in cooperation with the Coalition for the ICC and the Grootje Center for International Legal Studies of Leiden University. And tonight's lecture is moreover co-organized by the International Humanitarian and Criminal Law Platform, which is an academic network coordinated by the Israel Institute on International Humanitarian Law and International Criminal Law, in which 13 institutions from the Netherlands and Belgium participate. The attack by Hamas on the 7th of October of this year and the response by Israel has dominated the news for many weeks now. The conflict, which is affecting thousands of innocent civilians, is understandably stirring strong emotions and raising concerns about misinformation and even disinformation. As the saying goes, the first casualty in war is the truth. To provide an informed and factual perspective on this critical issue, we have organized this lecture to delve into various international legal aspects of the Israel-Palestine conflict, which hopefully will not only be interesting for ICL experts, but also for the public at large. This webinar will discuss three areas. So first, the use ad bellum, which refers to the conditions under which states may resort to war or to the use of armed force in general. And in this context, we'll address the scope of the right to self-defense. Two, use in bello, also known as the law of armed conflict or international humanitarian law or IHL. And this is the international legal regime that regulates the conduct of parties engaged in an armed conflict, and it seeks to minimize suffering during armed conflict by protecting and assisting victims of armed conflict. And in this context, we'll look at matters such as targeting. And then finally, the use post bellum, also known as the law of post-conflict justice. And that is the international legal framework that deals with the legal and moral implications of the termination of armed conflict. It encompasses the principles and norms that govern the transition from war to peace, including the establishment of peace agreements, the reconstruction of war-torn societies, and the pursuit of accountability for crimes committed during the conflict. And it's the latter aspect that we will be focusing on, addressing a specific crime, namely starvation. In addition to more technical questions, we will also ask a few meta questions that this conflict evokes. And the substantive scope of this webinar will be the Israel-Palestine conflict more generally. And we have intentionally picked this rather broad title so that any questions related to this conflict, for example, also the killings at the West Bank and actions by other groups than Hamas, for example, Palestinian Islamic Jihad, can be covered as well, if need be. But it's clear, of course, that the focus will be on the armed conflict between Israel and Hamas in Gaza. I'm pleased that we have found excellent experts who are willing to share their wisdom with us on these topics. And our first speaker will be Terry Gill. He is Professor Emeritus of Military Law at the University of Amsterdam, having held the chair from September 2001 until September 2020. And between September 2005 and July 2019, he also held the chair of military law at the Netherlands Defense Academy. Professor Gill was co-founder of the Research Forum on the Law of Armed Conflict and Peace Operations and was director of the research program on the law of armed conflict and military operations within the Amsterdam Center for International Law until his retirement, and remains active as a senior fellow in both of those platforms. Our second speaker will be Youssef Ziad Khan. He is a senior lawyer with Global Rights Compliance, which is a non-for-profit specializing in international humanitarian, criminal, and human rights law to address and alleviate acute humanitarian need. Mr. Khan provides expert legal advice to governments, international organizations, and NGOs on the effective implementation and enforcement of IHL. And for nearly a decade, he served with the United Nations, where he was responsible for the legal analysis of international crimes committed in the context of contemporary armed conflicts. He's a generalist international lawyer who has worked across many areas of the field focusing on IHL, ICL, and human rights law. And our last but definitely not least speaker is Helen Duffy. She's Professor of International Human Rights and Humanitarian Law at Leiden University and Director of Human Rights in Practice. And her research areas include counterterrorism, human rights in armed conflict, and non-state actors. And alongside her academic work, Professor Duffy is an experienced international human rights lawyer, specializing in international legal advice and strategic litigation. And her past roles include serving as a legal officer at the International Criminal Tribunal for the former Yugoslavia and as a legal advisor to the UK's Arms for Iraq inquiry. Thanks to all of you for your willingness to contribute to tonight's panel, and as agreed and for ease of communication, we'll continue this panel on a first-name basis. This webinar will consist of a moderated Q&A session with these three experts. I should stress from the beginning that this conflict raises many questions and that we cannot address all of these in the limited time we have at our disposal. And not addressing certain questions, therefore, does not mean we do not find these questions important. And of course, after my discussion with the experts, we'll open the digital floor for a Q&A session with you, the online participants. So please feel free to submit your questions online. Now, let's start with Terry and the use of bellum, in particular the scope of the right to self-defense. Several states have affirmed that Israel has a right to self-defense against Hamas, engendered by the terrorist attacks that took place on the 7th of October, while others, for example, Brazil, have argued that self-defense is limited to interstate use of force and that Hamas is a non-state actor. So Terry, could you give a brief overview of the debate surrounding states' right to self-defense against non-state actors? Thank you.
Yes, good evening, good afternoon, and good morning to all, depending on your time zone. Yes, it's a pleasure to join the webinar. Thank you for your question. Well, Christoph, this debate on whether or not self-defense can apply to armed attacks conducted by what we refer to as autonomous armed groups in an article that I recently wrote on this topic is one that precedes the Gaza conflict by quite a few years. I would say that the thinking on this has developed somewhat over the years. There's still, of course, basically 2 points of view on this. The one that you stated, put forward by the government of Brazil, that self-defense is restricted to responses against attacks conducted either directly by states or under the effective control of a state. Those two modalities of an armed attack were addressed directly by the International Court of Justice in the Nicaragua judgment of 1986. It did not address the possibility of self-defense being applicable to attacks by autonomous armed groups because that issue did not arise in that case. On the other hand, there's a considerable, and I would say growing body of opinion that does not restrict the scope of self-defense to attacks by states, either directly or indirectly. And I would say that in the years since the ICJ gave its advisory opinion on the construction of a wall in occupied Palestinian territory in the West Bank, that the thinking has shifted somewhat in the direction of allowing more scope for that right of self-defense. I could briefly mention a couple of points of state practice in that regard. One, of course, was 9/11, which triggered a huge response. And of course, everyone is familiar with that. And Professor Duffy here has written extensively on that issue. It's interesting to point out that in all the resolutions relating to the International Security Assistance Force in Afghanistan, which was active from 2002 until 2014, that they reiterated all the original resolutions, including 1368 and 1373, which declared that self-defense was applicable to the attack on the World Trade Center and the Pentagon. So that was a practice which was unanimously supported, I might point out, by the Security Council for over 10 years. We have other examples, not only by Western states, including Egypt, conducting attacks in Libya against attacks conducted by groups adhering to Islamic State. We have Kenya using self-defense in response to attacks across its border by al-Shabaab. We have Colombia invoking self-defense by attacks against its territory by FARC, located from Ecuadorian territory. And we have, of course, most recently, the practice related to the combating of Islamic State, which included attacks on Syria, which could only be justified under the guise of self-defense. Now, that included a coalition of states, some 15 states in the region, including both regional states as well as a number of Western states. But what's more interesting is the fact that a group of over 60 states diplomatically were involved in that operation and adhered to it. Now, that's a considerable body of opinion now over 20 years, I would say, that shows that states in different regions are invoking self-defense and not necessarily being condemning for doing so by the Security Council, on the contrary. So I would say that right now that the arrow is pointing more in the direction of a wider interpretation of that, rather than the more narrow one put forward by Brazil in the question you put to me.
Yeah, thanks a lot for this comprehensive answer. So indeed, assuming for now that Israel is indeed entitled to self-defense against Hamas, so which requirements must be respected while exercising self-defense?
Well, aside from the procedural one, which involves reporting it to the Security Council, the most important ones are the customary requirements of necessity ad bellum and proportionality ad bellum. I won't mention the third one that I sometimes refer to, immediacy, since self-defense was immediately invoked by Israel and was engaged in quite quickly after the attack. So there wasn't any considerable lapse of time between the attack. Now, the most important of these two are necessity and proportionality. Necessity refers to the existence of an ongoing attack or the existence of a clear and manifest threat of imminent attack or recurring attack in the immediate future. And proportionality in ad bellum terms, not to be confused with what we'll be talking about in a few minutes in the context of IHL, is a sort of combined quantitative and qualitative analysis. The quantitative part refers to the measure of defensive force in relation to the scale of the attack, and the qualitative element is that the amount of force used in self-defense must not exceed which is required under the circumstances to ward off the attack. Now, those two are crucial. Any act of self-defense must meet those requirements to remain lawful throughout. And these requirements are not just relevant at the moment self-defense is initiated, but they remain relevant throughout the exercise of self-defense. Okay? Would you like me to?
No, thanks a lot.
I think that's enough.
Maybe one follow-up question. According to a recent study published in an Israeli newspaper, 61% of those killed by Israeli airstrikes during the first 3 weeks of its campaign in Gaza were civilians. Professor Adil Haq has argued in Just Security that the total harm that Israel is inflicting on civilians would render its campaign as a whole disproportionate on the international law governing the use of armed force. Would you agree?
Well, yes, up to a point. See, the question is here, it seems like we're spilling over now. The two things are parallel. It's not the case that ad bellum stops being relevant once the armed conflict begins, but I would say that this sort of goes to the scale of the defensive force. In other words, but it isn't really a question of a head count. Is there a reasonable balance between the amount of force used in self-defense and the scale of the attack or the threat of further attack? And so that's one consideration. The other one, of course, whether or not how many civilians are being killed is I think more something that belongs in the realm of IHL proportionality rather than ad bellum proportionality. So I would partially agree with his analysis, yeah. Okay, yeah, I'll leave it there.
Yeah, and we'll go to proportionality in IHL as well in a few moments. Maybe before we go to the use in bello, would you like to add anything to what Terry has already said, Helen or Yusuf?
I would like very briefly to say something about the question of whether or not self-defense applies if we consider Gaza occupied territory or not.
Please. Yeah, please.
Now, this is controversial. I know I may be in the minority on this particular point of view. The ICJ's advisory opinion from 2004 related, of course, to the West Bank. The entire gist of that opinion was related to the way the barrier, the fence, the wall, whatever you want to call it, in the West Bank was being constructed and how it impinged on the territory of occupied territory. The conditions relating to Gaza at the 7th of October are totally different. As everyone knows, Israel disengaged many years ago from Gaza physically, although it maintained a considerable control over the access routes into Gaza and its airspace and territorial waters. Now, that to me does not equate to Article 42 of the Hague Regulations on Land Warfare's definition of occupied territory, where territory must be put under the authority of the occupying army, and they must and it involves the administration of territory by that army. On the face of that definition, I don't think Gaza qualified as occupied territory in 2007. That leaves us with the question of whether it was under the effective control of Israel, and their opinions are also divided. Now, I believe that it's pretty clear that after more than 4 weeks of intensive fighting with the entire Israeli army involved with the campaign in Gaza, it takes a little bit of imagination to think that on the 7th of October that Gaza was already under the effective control of Israel. If that were the case, I don't know what they've been doing there the last 4 weeks with the amount of fighting that's going on. So I don't think you could say that Gaza, despite the fact that Israel controls access routes into it, was under the effective control on the ground in Gaza when the attack took place. Therefore, I don't find the opinion of the ICJ in 2004 to be applicable to this situation.
Okay, clear. Yeah, thanks, Terry. Helen or Yusuf, would you like to add anything before we go to bello?
Maybe just briefly, Christoph, if I may, I was actually going to jump in on the question of occupation actually, and then Terry got in there. I think you could read my mind, Terry, so you jumped in before me. Obviously, that is a controversial question, as you said, and certainly for many purposes and many authorities would take the view that given the extent of effective control for a very long time over Gaza in terms of everything that we know, in terms of the control of what comes in, the control of what goes out, the control of aspects of everyday life, that Gaza would be considered occupied. So whether or not that means, of course, that self-defense in this particular context can't apply, I think is a difficult question. But I did want to say that, I agree with what I think something that Terry really emphasized is that this question of necessity and proportionality as an ongoing test is something that's really key here. And, I do think that while states rushed to affirm the right of self-defense, there hasn't been follow-up in terms of accountability as to whether the use of force that's being used on an ongoing basis is necessary and proportionate. And I do have a lot of sympathy with the Adil Haq article that you referred to in terms of just the sheer scale of what we're seeing has to be relevant to that question. And also the statements, I think, that are being made. I don't know if Terry would agree with that, but, understanding what are the aims of the use of force, what kind of accountability is there for explaining in what way the use of force is responsive to an ongoing armed attack and no more than is necessary. I think we're falling very far short in terms of justifying that on an ongoing basis.
Yes, thanks a lot. Would you like to respond, Terry?
Well, I don't want to get into a 1-2 on this. It's just a question of, I grant that there is a very considerable body of opinion that thinks that Gaza is occupied. I disagree, but it doesn't mean that I don't think that. I think that what often is done is that we want to not forget that Gaza is part of the Palestinian territories. Certainly the right of self-determination of the Palestinian people would include both the territories in the West Bank and Gaza. And of course, the Resolution 2625 from 1970 says that the right of external self-determination applies in 3 situations, one of which is foreign occupation. So one of the reasons I think that international bodies like the UN have reiterated that it is an occupied territory is to keep that on the table. And I completely understand and agree with that point of view. I don't think that the right of self-determination has been realized simply by the Israeli disengagement. There's still a lot of terrain to be covered on that respect. But the fact that you can fly over a kind of place or control interior or exit means that you can conduct a siege. And a siege is not the same thing as an occupation, in my view. Leningrad was surrounded by the German army for 3 years during World War II. Nobody got in or out. They cut off all the supplies from the outside. They bombarded the place on a 24/7 basis, pretty much. But Leningrad was never occupied by the Germans during World War II. Occupation means you have boots on the ground. Yeah.
Thanks, Terry. Okay, I believe there are no further questions also from or comments from Yusuf. So let's go to the in bello, or the laws of war, or IHL. Terry, again, can you explain to us the main steps in the targeting cycle and the IHL principles applicable to this cycle?
Okay, I will do that. Yeah, if I could, I would briefly, when we get into in bello, I'd just like to make a very brief preface statement. Most of what we're going to be talking about is analyzing Israeli actions in terms of IHL. That is perfectly valid and legitimate, but I think it's important to point out that IHL applies equally to both parties, and that the attack of the 7th of October demonstrated absolutely zero respect for IHL on the part of Hamas, period. Having said that, let's go to the targeting cycle. The targeting cycle is a military tool, if you want, which is used in a particular type of targeting, so-called deliberate targeting. In other words, pre-selected targets, usually engaged by air or by air artillery, whereby the commander and a team of people in the staff determine targets, first of all, which ones are subject to attack, prioritize them, assign weapons and assets to carry out that targeting, and then conduct the attack according to the assessment that has been made. Now, there are 6 steps in the targeting cycle that are used by most Western armed forces, and that would also include the IDF. And they include both setting out the objectives that are behind the whole operation. That's phase 1. And that's related to the jus ad bellum as well, because in this case, your mandate is governed by those conditions of proportionality and necessity that I referred to earlier. So if you think that you're going to conduct attacks, they must be within the scope of what is permitted in terms of relating it back to international law. Phase 2 is actually applying the principle of distinction. You determine which objects and persons are subject to attack. You identify, for instance, military installations or protected objects like hospitals and so forth. And you put on the latter group on a no-strike list. Phase 3 is assigning the capabilities at your disposal to the missions that you will conduct. So what do you have at your disposal? What kind of weapons do you have? What are you trying to achieve, and how are you? And here, proportionality questions, or at least the collateral damage estimates, will play a role in assigning which kinds of weapons you will use. And finally, you go on into the latter stages when the actual planning and conducting of the specific attack. That's where your proportionality analysis will be made, where you measure anticipated military advantage against anticipated collateral effects of a particular specific attack. Now, at bellum level, everything has to match at the macro level, you might say. In bello, we're talking at the operational and tactical level. So these assessments of proportionality are different than in the context of self-defense. They are referred to specific engagements by specific units against specific targets. And of course, that's, I think, is where I would agree with Al-Haq, because there you come to the overall effect of, you might say, the aggregate effect. And that has been extremely far-reaching, to put it mildly. There's been a lot of firepower put into place, and enormous amount of ordnance has been launched. And the question would be whether or not that does not cause what is referred to in IHL terms as excessive, disproportionate damage and injury. And that's something that is difficult to judge on an individual attack basis, but if you take a more telescopic view, it looks like there's a very general opinion, not only by IHL people, but in terms of the international community at large, that we've reached a point where it's either become disproportionate or is already or is at least at the tipping point. So I think that covers your question on the targeting cycle. The last phase is assessing, and that's where accountability comes in. That's where you would do a report and give an estimate of what the effects of your attack were and investigate any possible violations of IHL. So these are the steps that you would take and how IHL and international law relate to them.
Excellent. Thanks, Terry. Maybe let's zoom in on a few of these principles and apply them then to the situation in Gaza. Do you think that is it possible, and if so, how, to respect a principle like distinction in such a densely populated area like Gaza? And this is also taking into account the latest reports that nearly half of the Israeli munitions dropped on Gaza are imprecise so-called dump bombs, according to a US intelligence assessment.
Well, yeah. Well, the dump bomb would have, of course, in the sense that it's not necessarily an indiscriminate weapon. It depends on how it's used. But you're making a good point. We're dealing with a very densely populated area. One of the questions that again, I'm not trying to be an armchair general here, but one of the questions that has bothered me with this whole targeting thing is that a lot of ordnance, as I said, I believe that somewhere more than twice as much has been expended in the 4 weeks or a little bit more than that of the campaign than during the entire campaign against ISIS over a period of years. That's a whole lot of ordnance. And I just wonder why that was necessary from a military point of view, if you take into account that the reports that I've read stated that Hamas's command and control centers and arms dumps were located largely underground in tunnel complexes. So what exactly are you trying to achieve by this level of aerial bombardment? And there we go to the question of what is your anticipated military advantage from specific attacks? So that raises that question. I'm not saying that that's the end answer to this thing. There's always a lot of information one doesn't have at a distance, but it certainly that situation raised that question with me. And of course, proportionality and and precautions in attack are directly related to distinction. And so with the, and of course the tactic of the passive precautions, in other words, the fact that Hamas is not located in separately or doesn't try to distance itself from the civilian population, plays a role, a very big role as well. So all these factors together have contributed to the number of casualties, but that doesn't in any way relieve either party from their obligations to mitigate civilian damage as far as it's possible. And the congested nature of the targeting area is a factor that has to be taken into account, but the obligation still is there on both sides.
Yeah, thanks a lot, Terry. In view of the time, I suggest that we now turn to Yusuf and the topic of starvation, also discussing this first within the context still of IHL and in bello. So on the 9th of October, Israeli Defense Minister Gallant said, "We are putting a complete siege on Gaza. No electricity, no food, no water, no gas. It's all closed." Then 2 months later, the Deputy Executive Director and Chief Operating Officer of the World Food Programme, Karl Skau, said that there's not enough food and people are starving. So Yusuf, can you explain what starvation is as a method of warfare, and what does IHL say about this method? I think you're muted, sorry.
Thanks, Christoph. Under the Rome Statute, starvation as a method of warfare means intentionally using starvation of civilians, quote, as a method of warfare by depriving them of objects indispensable to their survival, including willfully impeding relief supplies as provided for under the Geneva Conventions. AP1, Article 54, regarding the protection of objects indispensable to the civilian population, underscores the starvation prohibition, which is viewed as a customary international law prohibition, as well as AP2 from NIACS. Under customary IHL Rule 53, you will see the same corollary prohibition. With respect to what it means regarding OIS, or objects indispensable to the survival of the civilian population, AP1, Article 54 delineates some of these objects, such as foodstuffs, agricultural areas for the production of foodstuffs, crops, livestock, drinking water installations, supplies, and irrigation works. When you really dive into what these OIS prohibitions that attacking, destroying, removing, or rendering useless OIS means, it's really context specific. So it matters with respect to what the specific population needs, with respect to how those objects are indispensable to their survival. So if you look at, maybe we can start from 2015 or 16, when the prohibition of starvation really started entering the public domain in a renewed way. If you start with Madaya in Syria, or Aleppo in Syria, or Eastern Ghouta in Syria, and then you look at Tigray or Mariupol in Ukraine, you start seeing where different populations had to turn for their resources. In Madaya, they began resorting to eating domesticated animals or grass. In Mariupol, they began melting snow in order to get potable water. In Eastern Ghouta, they began incinerating trash or garbage in order to achieve heat, warmth, electricity. So it's a very contextual analysis that one would have to entertain. With respect to what it means, quote, as a method of warfare, I think it's quite interesting in the occupation context, because as we know, starvation as a method of warfare is unsettled. There's never been an international prosecution in this regard. So in the occupation context, when we look at what it means as a method of warfare, we have to look at whether or not hostilities reach the method of warfare threshold. Regarding Israel and Hamas in the current context, of course, there is that threshold of hostilities that's been reached. But if we look at instances, for example, of Russia's occupation of Ukraine, in Mariupol, in other areas, can the occupation framework under GC4 apply, or do we pivot back to as a method of warfare? These are unresolved questions that I think are being teased out. Another thing I would mention is regarding intent. When we say intentionally using starvation of civilians as a method of warfare, are we talking about oblique and indirect intent? Can we look at the ordinary course of events or foreseeability, or are we talking about direct intent? In this specific context, we have statements by senior military officials and senior government officials where they are almost boasting cutting off access to food, water, fuel, wheat in a way that we haven't seen. So if we go back to what I mentioned regarding the past 8 years or 7 years since the siege of Madaya in eastern Aleppo, where starvation has entered this new discourse, there has never been public statements by high-level military commanders that have reached the sort of threshold that we're seeing now in Gaza. And that's extremely important because whether or not the ICC will take this on, I mean, we saw that Karim Khan has mentioned the denial of humanitarian aid and starvation on 4 separate occasions. I think they not only direct and indirect and oblique intent, but they also have directed intent in this context. Yeah, maybe I'll leave it there. And
yeah, thanks a lot, Yusuf. Before we go to the use post bellum, where we also discuss and continue discussion on starvation, is there anything one of you would like to add to what was said in this part of the webinar, so the in bello part? No?
Very briefly, I would just like to say that I agree with what was just said by Yusuf. It seems to me that the intent here is fairly clear. There was a quid pro quo, I think, at some points, certain points were raised that relief supplies would only be let in if Hamas started releasing hostages. That sounds like you're using the relief supplies as a bargaining chip to achieve a particular war aim, with, of course, the civilian population being the direct, you might say, recipient of that particular policy. It looks to me like you're talking about a form almost of collective punishment to achieve a particular kind of objective. That's been a banned method of warfare for a long time, even right after World War I. That was considered to be so, if one considers that. Of course, it's usually seen in terms of taking hostages and conducting executions of persons as a retaliation against resistance fighting. But the cutting off of relief supplies or making it conditional on a particular action by the adversary is arguably a form of collective punishment. I'll just leave it there.
Maybe I could jump in. Yeah, I could jump in. Recently, on just security, there was about 5 or 6 experts that weighed in on this specific issue regarding conditionality when the U.S. Made a comment with respect to conditioning hostage taking as it relates to aid. And I completely agree with Professor Gill in this context. I think all of the experts who weighed in noted that conditioning humanitarian aid on hostage release is completely antithetical to IHL. So yeah, if the audience wants to search that article up, there's some background there.
Thanks a lot. Okay, then let's move to from the use in bello to the use post bellum and the pursuit of accountability for international crimes. You already hinted to it already. So, Yusuf, under what circumstances would the deprivation of food and water as a result of the blockade amount to the war crime of starvation? So which elements does the crime of starvation contain exactly? Okay,
so with respect to the elements, the perpetrator deprives the civilians of objects indispensable to their survival. Of course, food and water would black letter fit that definition. And we also looked at other examples of OAS in the previous question. The perpetrator intended to starve civilians as a method of warfare, and then we discussed just now oblique versus direct intent. The conduct took place and was associated with an IAC or NIAC, and the perpetrator was aware of the actual circumstances. Here, I would also perhaps add that if we're just looking at elements of this crime, let's perhaps maybe tease out a little bit more on the siege, because I think there's a little bit of a back and forth with respect to blockade and siege. So a lot of what your audience may read is that Gaza has been under blockade for 16 years. And Professor Gill just mentioned this in his intervention. And then what does the siege mean in this context? So under Geneva Conventions 1, 2, and 3, you have a reference to besieged and encircled areas, but you don't have an international legal definition of the term siege. But I think for purposes of our discussion, if we're going to discuss a besieged area, which matters quite a bit with respect to how aid can come in and out, and what it means with respect to starving civilians, we can rely on the definition of siege, perhaps from UN OCHA, which is the Office of the Coordination of Humanitarian Affairs, which says that it's an area surrounded by armed actors with the sustained effect that humanitarian assistance cannot regularly enter and civilians, the sick and wounded, cannot regularly exit the area. So I think by definition, this is a besieged area, at least from the humanitarian perspective. If we want to tease out the military perspective, we can. For example, Professor Mike Schmidt and others over at Articles of War will have their say, but I think for humanitarian purposes, we can refer to Gaza being a besieged area rather than a blockade. Thanks, Christoph.
Thanks to you, Yusuf. Maybe final question before we go to Helen. So at present, deliberately starving civilians as a method of warfare can be prosecuted before the ICC only when committed in an international armed conflict. The crime of starvation in non-international armed conflicts has been incorporated in the ICC statute by amendment in 2019, but this amendment has not been ratified by Palestine. So does the qualification of the conflict as international or non-international impact the prospects of pursuing accountability in your view?
That's a really interesting question. I think we can say a couple things. First, it would be my presumption that the ICC would view this as an IAC. Again, if you look at statements by Karim Khan, the 4 statements that he's made with respect to humanitarian aid, the presumption would be that this would be viewed as an IAC, but it also depends on what we mean by accountability. If we're looking at ICC accountability and international criminal accountability, we're looking at a different standard of proof than we are, for example, with respect to UN mandated mechanisms or COIs. If we're looking at reasonable grounds to believe versus, beyond a reasonable doubt. I would say in this context as well that starvation crimes tend to manifest not only through the intent to starve civilians, but there are concomitant crimes. Again, if you look over the past 12 years, how sieges manifest, you tend to have a series of crimes. So a study, a cursory survey of UN mandated mechanism reports, for example, in Syria, as well as in Ukraine, as well as in Ethiopia, you start seeing that collective punishment is a crime. Obviously, it's not a Rome Statute crime, but it's a crime that tends to be concomitant with starvation as a method of warfare. You also see forced displacement. There's a starvation displacement nexus that tends to occur. So it's not necessarily only starvation that one would have to look at, but it's this sort of series of crimes. So collective punishment, starvation, forced displacement, as well as perhaps the crime against humanity of other inhumane acts. With the respect to the crime against humanity of other inhumane acts, I want to be careful because we're not, I think, at the place yet where we can say that there was a widespread or systematic attack directed against a civilian population in Gaza, although it seems increasingly close. However, with respect to the gravity threshold of other inhumane acts, about 2 months ago, when we started seeing displacement, we started seeing, scholars like Shane Darcy saying this is the worst collective punishment that he's seen in 20 years of working on the crime. We start, being able to build the logic. And now what we're seeing is the WHO, the WFP, and others saying starvation is actually occurring. So nobody's warning anymore. We're starting to see severe acute malnutrition and malnutrition sort of being documented in a way that may meet the gravity threshold of other inhumane acts. So that's another crime which may be viewed, Christoph, if that, yeah, thank you.
Thanks a lot, Yusuf. Let us now turn to Helen. Another element of the use post bellum is also the issue of reparations for victims. Helen, you have been involved extensively in conflict-related litigation. Can you say a bit more about the role of litigation in these kinds of contexts and some of the challenges that victims may face, for example, in securing reparation?
Well, thank you, Christoph, very much for that. I think maybe the first thing to say about litigation at the outset is, during a conflict and in the sort of situation that we're in at the moment in Gaza, that the role of litigation is relatively limited. Talk about reparation, but of course the first aspect of reparation is cessation, so it's bringing to an end the violations. And so I think we can acknowledge that for many people, understandably, both on the ground and elsewhere, it may not be seen as the priority. So I just wanted to recognise that, I think, before talking about the possibilities and some of the challenges. I think in terms of litigation, I think, can take many roles. It can take many forms and play different roles, I think, in this conflict. I think for the most part, one of the limitations is foreshadowed in your question, where you refer to it as post-bellum. And actually, I think one of the interesting questions is, can litigation play a role during the conflict? And can it play a role in helping to shape that conflict and to minimise the violations that occur during it? I think the answer to that is probably relatively minimally, but it is an interesting question. I think we need to look more at whether we can maximise that input that the litigation might have in that situation. But we do see some examples of that recently, for example, in the UK, in the Netherlands, for example, there has been efforts by NGOs that you may be aware of to try to prevent the export of arms equipment, or I think in the Netherlands it was transfer of fighter planes, I think was the litigation. I wasn't involved in any of that litigation, but I understand there's a judicial review in the English courts and another claim here in the Dutch courts. There's also a claim brought by NGOs in the United States in relation to whether there's obligations of the state, the United States, to prevent genocide, but they're failing. And this we might think of as strategic litigation. Whether or not that litigation will ultimately succeed through the courts, we don't know. We do know in the case of the Netherlands that it was thrown out. But of course, in a way, I think what NGOs are trying to do here is to shine a light on issues, to shape the narrative a little bit, and to increase the pressure on third states in that case to meet their obligations and not to contribute to the conflict. But more commonly, of course, with litigation, we'd be thinking after the fact, thinking about criminal accountability, maybe civil accountability. We would also maybe be thinking about the accountability of states in international fora of some type or another. I think it is really important to think about this question during the conflict, even if ultimately that litigation won't happen until the post-bellum stage, if you like. And that's partly because I think it's important to send the message at this time about accountability and about the prospect of accountability in order to try to have an influence on conduct and violations in real time. So the messaging about the prospect of criminal accountability at the International Criminal Court, of course, but also in the national level, through the exercise of universal jurisdiction, for example, is, I think, an important part of the role that litigation can play. Maybe turn to a couple of challenges. I'll maybe mention 3 challenges quickly, as you asked. There are many, obviously, huge challenges to litigating or giving effect to litigation in armed conflict situations. I'd maybe say, the challenges are practical, political, and legal. So maybe mention one of each of them. Obviously, on a practical level, it goes without saying, evidence gathering in the context of a conflict, getting access to areas in the context, in that particular context, access to evidence, access to people, access to areas, huge access issues and evidence gathering issues. That really is a priority now, I think. Again, even though it may not be a priority, quite understandably for people on the ground, we do, of course, need to ensure that the evidence is there when eventually it might be used and circumstances change, but hugely challenging. Second one, I think, is politics, of course, is the prioritization of which cases will be prosecuted, investigated, and which will not. And of course, there've been many references to double standards, the whole discussion around the role of the ICC. But likewise, you know, if we look historically, there've been many efforts to try to use universal jurisdiction in respect of Israeli officials in the past accused of serious crimes, and those have never gone forward as a result of various predominantly political factors, I think. So politics clearly a huge issue here that we have to reckon with, the intersection between law and politics. And the last one is maybe legal and jurisdictional, but linked to politics, which is, you know, where can these cases be brought? You know, we know that on the international level, we don't have an IHL. You know, we have human rights courts, but we don't have IHL courts, of course. We also have the reality that the human rights mechanisms are not available because Israel has not accepted individual communications before any of those mechanisms. So the options that are available in some contexts are not available here. In Israeli courts, there are many really interesting and detailed reports about lack of access to justice on the part of Palestinian victims in particular, where alleged violations arise in the context of Gaza and armed conflict. So legal obstacles as well as practical obstacles. And then maybe the final one that I'll mention, Christoph, it's a very long answer, sorry. Never asked me about challenges or litigation, or you get too long an answer. But the last one I'll just mention because it relates to a case that I mentioned to you, a case that's being filed this week in the European Court of Human Rights, where I represent a Palestinian Dutchman who lost his family in 2014 during Operation Protective Edge. And the Dutch courts in that case, when he brought a civil action against former Israeli military commanders, the Dutch courts threw it out on the grounds of functional immunity, finding that there was no exception for war crimes and it didn't matter that he had no other avenue. So this is an issue that we're now taking to the European Court of Human Rights. But this kind of broad approach to functional immunities of former officials, including for war crimes, is, I think, another example of the many obstacles that victims face in trying to bring civil action as well as to pursue criminal remedies.
Yeah, thanks for that elaborate answer, Helen. And I know that you're very busy also with that filing, so much appreciate you being here. Maybe in the context of starvation, we already talked about, well, of course, international criminal law and thus individual criminal responsibility. Let's also briefly address the issue of state responsibility. You already touched upon it. Can you say a bit more about the role and responsibility of third states in these kinds of contexts? For example, how does international law address scenarios where third states assist other states in carrying out unlawful attacks, for example, through arms transfers?
Thanks, Christoph. So you've said the word brief, so I promise I'll try this time. I suppose there are a couple of obvious provisions of international law that we could think about, and it is really important to ask about the role of third states, I think, and the responsibility. You know, the first one is, of course, the Common Article 1, International Humanitarian Law, Common Article 1 of the Geneva Conventions, the all state parties will respect and seek to ensure respect for IHL. So to what extent does this impose obligations on third states to do whatever they can in order to ensure that IHL is being respected? And of course, what states can do will depend on their influence in their relationships. But you know, we have seen in this context states expressing a great deal of support on the one hand, and perhaps failing to use their influence to bring to an end the violations on the other. So there's that provision. And then there's the question of whether or not states may even be aiding and assisting in violations, you know, under the law of state responsibility, Article 16 of the ILC articles, that states may be responsible for aiding and assisting in violations where they're actually making a direct and concrete contribution. So I think if we're talking about arms transfers in a situation where there is knowledge that violations are unfolding and there's a direct and concrete contribution, so it's quite a high threshold, where that arises, then I think there are also questions about, I've been told in the chat that I'm a little bit far, sorry, from the mic. I think there are also then questions about whether states may even be responsible for aiding and assisting in violations in that context.
Thanks a lot. Maybe a more general question related to counterterrorism. So the 7th of October has been called Israel's 9/11, followed by a warning to not disproportionately respond to terrorist attacks. Some say Israel has stepped in the horrible terrorist trap, which indeed, as Terry mentioned, violates all rules of IHL, placed by Hamas, in the same way as the US stepped in the terrorist trap placed by Al-Qaeda. Would you agree? And what are some of the lessons from the war on terror that we should keep in mind when considering accountability in relation to the situation in Gaza?
Thank you, Christoph. I think clearly, as has been said, October 7 being such a terrible atrocity, I can completely understand the comparison in terms of the profound impact that is going to have on a great deal of people. In terms of the responses to it, of course, I have really been struck from the beginning by how many of the responses do remind us of that 9/11 moment. And you ask about lessons from that. I think, again, maybe the three to highlight. One of them is, of course, the whole notion of terrorism as being a profoundly unhelpful one in this situation. Terry already referred, of course, to the sort of crimes that October 7 entailed, and better to refer to them as war crimes, questions of crime, as crimes against humanity, I would say, rather than to use the terrorist label. And we do get questions coming up as to the use of terrorism, even by, I think it was a speech by the ICC prosecutor where he made various references to terrorism and terrorist groups. I think maybe one of the lessons of the war on terror is just better to talk about well-established international law and not to use this label that has been so abused in the war on terror and is seen to be and often is so politicized. The second and the big lesson, I think, is about effectiveness and counterproductivity. I think when we see very excessive reactions that are seen to be flagrant violations of international law, and the question is, are they counterproductive? Does that ultimately contribute to the spread of so-called terrorism or acts of violence and further criminality, that kind of spiral? And of course, there are many, many reports in the context of counterterrorism that does suggest that a lot of action that states took in the aftermath of 9/11 that violated international law were counterproductive for security. UNDP's report on Journey to Extremism in Africa is a very good example of that, but as you know, there are very many. So I think we really do need to have that long-term view that can be so hard in the context of conflict. And then I think the last one would just be, I think, the lack of accountability and the importance of accountability and making sure that that does happen for war crimes or crimes against humanity. And in the war on terror, of course, the lesson from there is there has been no accountability. I think it really undermines the ability of many states, including the United States that led it, of course, to now be advocating. It should be doing a better job of advocating, in my view, but to now to be, of course, calling on other states to meet their obligations. So I think the importance of accountability and learning lessons, which I think we really have failed to do in the war on terror, as many people reflected on its 20th anniversary, is something that we should bear in mind if we want to avoid many long-term implications of this conflict in the future.
Yeah, many thanks. Couldn't agree more. Terry and Yusuf, would you like to add anything to this before we go to two meta questions? No. Okay, so we have two meta questions. So some have said that this conflict shows that the law, especially IHL, needs to be further developed. Do you think that is the case, or not so much that the problem is the law here, but more the problem of the inability of states to enforce the law? And my second question is, and this, by the way, goes to all the members of the panel, so I'm not specifically addressing it to one person. And the final question is, what can and should we do as international lawyers, except not becoming cynical and continue stressing the importance of respecting international law? So who would like to take the floor?
Well, I'll lead off just to say a couple of brief words on this. I this is the kind of question that you always get when you teach IHL, and it remains one of the core questions that any IHL lawyer or international lawyer has to face. Obviously, there probably is room for some improvement or fine-tuning of some of the rules, but I don't think that the biggest problem is a lack of rules in this situation. Whether you classify the conflict as an IAC or a NIAC really doesn't make that much difference in terms of the applicability of most of what we've been talking about tonight. So there is, I think, quite a sufficiency of rules. What of course is missing often in wartime is both a system of accountability, as was just said, but accountability assumes that the party in question is interested in enforcing IHL to begin with. And of course, one of the parties to this conflict is probably not, at least not in my view. So that's a problem. And how do you make up for that? In the old days, IHL was based on the concept of reciprocity. You applied IHL if the other side, by and large, did the same thing. We abandoned that after World War II because of the incredibly bad effects that had, and rightly so. So in my view, the equality of belligerence here means at least that both parties are under equal obligations to meet IHL, and the efforts of the international community, because that's where it boils down to, should be aimed at bringing to justice those people who are most responsible for the worst violations, and putting pressure on the parties. Both, I think that even a party that's not interested in IHL as such will be interested in the international support that it can maybe lose or not lose. I think the importance of IHL is actually underlined on the way that it has focused the entire attention of the world on this conflict. The perception, one way or the other, of adherence to IHL or lack thereof has fueled a lot of reactions, both by states and by non-state actors, by the civil population at large, by NGOs and so forth, by the United Nations. So I don't think there's any question of the relevance of IHL. It's a question of how to best enforce it. And I would say maximum pressure on both parties to meet their obligations is what we need to do. That can be diplomatic, that can be through court procedures, that can be through arms supplies being made conditional on meeting IHL obligations, and so forth and so on. So those are my words of not so wisdom on this particular topic. Yeah.
Thanks a lot. I think they're very wise, those words. Helen, Yusuf, would you like to say something as well?
Do you want to go first, Yusuf, or no? No, you look like you. Yeah, no, I mean, I agree. I think with what Terry said, and I think it's not so much gaps. I mean, of course, there are areas where the law could be clarified. There are areas where it's challenging to apply it. There are questions and disputes, but I think not so much inability of states to enforce it either as unwillingness quite often to do so. And I think we have to really reckon with that problem of, I think, selective application and enforcement of the law, which I think is a huge issue that we face here. But I think certainly there have to be efforts to enforce it with all parties, and as we've said, with third states. But I think that's all I'll say at this point, so we can open up for questions. I see a busy Q&A there. Thank you.
Thanks, Helen. Yusuf?
No, I would just say, I mean, as long as we're going to be sincere about some of the elephants in the room, we have statements from both parties that are completely antithetical to IHL. I mean, we have the Hamas leadership on Member TV saying that if they could, they would recreate this attack every day, for time until they wouldn't be able to do it as such. And then we have, the Israeli statements with respect to siege, starvation, and dehumanizing language regarding animals or beasts. So these are all things that need to be contended with as well. I mean, we can't ignore these things. They're actually quite rare. Again, I'll re-emphasize this, that parties to the conflict are making such statements. They need to be preserved, and they need to be looked at with respect to further analyses, not only regarding attacks, but regarding how parties are approaching their international legal obligations. And I think it's extremely important because, again, if you look back over the past decade, you have some of the most stark statements and intention to attack or encircle or besiege or starve civilians from both parties that you may have seen. I haven't seen it in the course of a decade of working on such crimes. So it's really important that we're honest that both sides bear fault, possibly, and also are being quite sincere about what their motivations are. So thanks.
Yeah, thanks a lot for that. Okay, we've now concluded my sort of moderated Q&A with you. There's now some time for Q&A with the audience. My colleague Anna-Maria Nagria has selected a few questions, and there are many. Thank you so much, by the way, for your interaction. Maybe a first question is on the use ad bellum. So for how long can Israel continue its military operation under the right of self-defense? So does use ad bellum cease to apply after a certain point?
Well, no, the answer to that, my view, is that use ad bellum remains applicable as long as force is being applied, period. There's no automatic shutoff point there. Although there are people who think that it only applies at the first moment and that thereafter it's not really all that relevant, but I don't agree with that. It's more a question, I think the question kind of goes to how long does Israel retain, assuming that it has a right to self-defense, how long does it retain that right? Well, that would only be the case in two situations. First of all, the most important of that is the necessity. That's the driver and also the limiter of self-defense. If there's no continuing necessity of self-defense in the sense that there's no attack or recurring attack in the reasonably proximate future, then the right of self-defense ceases to be applicable. The second is that if you exercise self-defense in a way which exceeds the limits of ad bellum necessity and proportionality, your actions become unlawful and therefore become no longer actions in self-defense. So I'll leave that for what it is. My own opinion is that in terms of the necessity, that it's an arguable case that there still is a necessity for Israel to continue, since Hamas is still there and still is capable and willing to carry out attacks. But on the other one, I'm not so sure. I think that we've reached a point where the question of whether or not the level of self-defense has reached a point where it exceeds what is required under the circumstances to ward off attacks in the reasonably proximate future, that there are not other ways that are less damaging to achieve that object. I think that's also very arguable. And in that sense, I think that the right of self-defense could now consider to be lapsed because of the question of proportionality, combination of ad bellum and in bello there. That would be my answer.
Yeah, thanks a lot, Terry. And Alan, Yusuf, please feel free to jump in if you want to add something, or if you disagree. Another question that was put in the chat is one on IHL. Given that there is no requirement to share information on how targeting calculations are made, how can the proportionality principle be made meaningful and effective? Again, this would be a question for you, Terry.
Well, it's primarily, I think, a responsibility of the party that's employing force. It's extraordinarily difficult to make proportionality assessments after the fact and from a distance of time and space. And that isn't because proportionality is meaningless, but it's because it's contextual. it's based on information available at the time the commander makes a particular decision to engage a specific target. Without having that information, what are the conditions on the ground? How many civilians are present? What kind of weapons are at your disposal? What kind of effect do you want to create? How many, are we talking about a high-level commander you're targeting, or is it not? All these things enter into whether or not it's a proportionate attack or not. Of course, after the fact, when you have all the facts, you can assess whether or not a party met these obligations or not. But the actual moment in which you have to judge whether or not it was proportionate is when the attack is carried out. Now, that makes it difficult for third parties, as it were, to enter into it, because, like you say, no one is sharing their targeting information, and that would really that would be almost absurd. It would mean that every single engagement you would be engaging in a sort of across-the-board discussion with I don't know how many audiences to determine whether or not you could engage the target. So obviously ex post is the way it will be assessed, even though it's the targeting information is relevant at the time the attack is carried out. I don't see any way around that personally.
Yeah, thanks a lot, Terry.
Just
please,
jump in
Helen,
a bit
please.
on that, because it is a difficult one. I mean, obviously, what Terry says is absolutely right. I mean, and of course, there are limits on the sort of information. I mean, there's no point in talking about a very broad access to information, right to truth conversation in this context. Of course, that would be too far reaching. And of course, there are limits. But at the same time, the onus does have to be on a party, doesn't it? The party that is carrying out the attack to justify that attack. And even if we're not talking about identifying targets in advance, we are talking, I think, about providing enough information that it's possible to make some kind of meaningful assessment about lawfulness as the conflict goes on. And I would say for third states that are certainly those that are cooperating and participating, they have to have that information in order, I would say, that they're not contributing to violations on an ongoing basis. So again, I mean, the onus is on the party that's carrying it out. Of course, there are practical limits, but we can't be too afraid, I think, to insist on more information and transparency, because that's the only way that we can hope to try to influence violations in the future.
Yeah, thanks a lot. Please, Yusuf.
Thank you, Christoph. I would just jump in and also say that the way that UN mandated mechanisms have viewed certain patterned attacks is that, for example, if there are no effective events warnings, if you see hospitals continuously being attacked, if you see schools continuously being attacked, at some point when no information is being provided regarding forces, opposition forces, at some point you have to concede that there's something to be discussed. So in the Gaza context, I think that's what we're seeing when we talk about 140 UNRWA staff members killed, journalists being killed, en masse, schools, hospitals. There's a conversation that really needs to be had with respect to how much we're willing to let go and how much we have to interrogate. Thank you.
Thanks a lot. A question has come in for Helen. Does universal jurisdiction offer a proper legal avenue for strategic litigation in this situation? And could immunities represent an obstacle?
So in principle, universal jurisdiction is one of the avenues that can be used, and we are seeing, I think, actually, a very active landscape of universal jurisdiction recently. We've seen many cases in a growing number of countries actually using some form of universal jurisdiction. Quite often, there's some kind of link with individuals in the state's territory, but not necessarily. So there are a variety of different practices and different laws, but there are, I think, a growing range of options in terms of universal jurisdiction. The problem is politics, as I mentioned before. To what extent the litigation can be used as a tool by victims, by NGOs, by others. But very often when we're talking about universal jurisdiction and indeed criminal complaints in general, very often, not always, but very often, there is some form of political choices and prioritization that's made. And certainly the record on universal jurisdiction, as I said before, in respect of Israel is, I think, a problematic one. State immunity, functional immunities, as I mentioned, I'm up to here with functional immunities this week as we're filing this case actually tomorrow at the European Court. It is a difficult area of law. There's no doubt that immunities have operated as obstacles to pursuing justice in the past. Certainly in respect of cases against states, that's particularly problematic. You know, what we're arguing this week is that when we're talking about functional immunity and you're talking about the individual responsibility under international law, then of course it should be possible, we would say as a matter of current international law, it is possible to pursue individual responsibility for war crimes, and immunities simply shouldn't apply to individuals in those situations. But yes, they can be an obstacle that we need to try to engage and overcome.
Thanks a lot. In view of the time, maybe one final question to Yusuf. Do you think there is enough evidence to suggest that apart from war crimes, other international crimes might be committed as well? You already mentioned crimes against humanity, but are there, for example, reasonable grounds to believe that the siege of Gaza could amount to genocide?
It's probably the most extremely complicated question, and it's one where friends of mine and scholars fall on both sides. For anyone who's interested, I would recommend that you read the Tuelar genocide note, which a number of scholars have signed. If you want to look at how genocide may be viewed, they call it a slow motion genocide or something to this effect. For myself, I would say this. I have seen similar tactics and similar, if we're just going to start on October 7th, we're not going to look at, for example, 16 years of blockade. Because 16 years of blockade, what it means for children and women and other vulnerable groups in Palestine, it means quite a lot. If you look at how their development is being hindered and with respect to how the lack of nutrition, etc., is sort of manifesting with respect to their, with respect to how they are existing in the international community, it's quite a harrowing story. But if we're just going to start on October 7th and we're going to put all of that aside, I think then you have to look at what the siege context means in Ukraine, in Syria. When you cut off objects indispensable to the civilian population, could that amount to genocide in other contexts? Right now, what we have is likely a very, very well-enforced siege, a desire to displace the civilian population, a desire to ensure that the civilian population of Gaza will not go back to the north, complete demolition of their homes, etc., etc. But you see the same thing in Ukraine. You see the same thing in Aleppo. You see the same thing in Eastern Ghouta. You see the same thing in Tigray. Why is this a genocide and why is that not a genocide? So it really comes down to how you view the facts and whether or not you want to go back during this period of blockade of 16 years, and whether or not you want to view the facts in a sense separate to other sieges that we've seen over the course of the past decade. I would say, based just to underscore the point, based on this analysis, where it's quite premature to determine genocide. However, if you're going to look at the conflict as a narrative, there are reasonable grounds to believe that this could form part of a genocide, as again Bill Shade said a couple of days ago. Thanks.
Thank
you so much. Yeah, Helen, I see you muting yourself, please.
Yeah, just to add, I think to what Yusuf has said. I mean, two things. I think I'm not going to answer the question of whether this is genocide or not in a simplistic way. I think there are complex issues. I'll confess to having been quite sceptical, even in the aftermath of October 7 and as we saw things begin to unfold. And I'm increasingly of the view that there is a very serious argument here that there is at least a risk of genocide, and I think we need to take that extremely seriously. Of course, it is a question of not only the facts and what's actually happening on the ground, but also the intent, and that special intent being such a key element of genocide. And I think the more that we see statements from many people within the Israeli administration, I have to say that they're very troubling. And I don't think every statement that someone should be made should be jumped on and say this is genocidal. I think we have to look across the board, but I would have to say I think it's a very incriminating dossier that emerges as you do that. And then just finally to say that, of course, on Yusuf's point about being premature, although I understand what you're saying, Yusuf, I would also say that, there is an obligation to prevent genocide, and that's very clearly enshrined in the Genocide Convention, very explicitly and unusually, actually, in international human rights law, in terms of a broad duty to prevent anywhere in the world. And I think certainly that obligation is triggered by Gaza and in Palestine more broadly, perhaps today.
Thanks a lot, Helen. Terry, any final observations that you want to share before we conclude?
Well, one thing we haven't talked about is what after. The major question that really bothers me a lot is that after this conflict reaches some kind of ceasefire situation, which I think is going to happen within reasonably near future, I think that within the next weeks that there will be a ceasefire pressure on Israel, which will be irresistible, and that will, at least in this phase of the conflict. The way forward, though, is very less clear, and I think it's going to take a huge effort to not only make sure that that the violations of IHL and other international norms that have occurred are brought to attention, and where possible, some kind of accountability is done. But more important, I think, rebuild and work for some kind of solution. And I guess you should have a separate conference on that, because I think that the whole point of any armed conflict is to bring about some kind of settlement of the issues. Otherwise, it's just another armistice. And then we're waiting for another 7th of October and another reaction by Israel. So unless we can break this cycle, it's been going on for a long time. And this is just the worst phase in it. We're going to just see this coming back and again. So I really would like to see a major effort by the international community to once and for all bring about a solution to the Palestinian situation. And, whereby Resolution 242, and everybody knows the solution. It's a question of implementing, and that I think is really where we should be concentrating our effort on now. Well,
absolutely. Thank you, Terry. In view of the time, I would like to conclude. Many thanks for your questions and very detailed responses. And sorry you could not put all the questions to the panel. I think this has been a very interesting evening, and I hope that I speak also on behalf of the online participants as well. I would like to thank our co-organizer, the IHCL platform, my colleague Anna-Maria Negria for helping with the questions and monitoring the online chat, as well as our events team, namely Alexandra Pinto-Damas, Alicia Garcia, and Leonardo Pavan, as well as Wouter Lemaire for IT support. And I would also like to thank you, of course, the audience, for your attendance and good questions. And finally, and most importantly, I would like to thank our experts, Terry Gill, Yusuf Ziad Khan, and Helen Duffy for their insights and wisdom. And with that, I would like to conclude this webinar. Please check the ASSA website for more events on IHL and ICL. And the first one is a highlight lecture entitled Hate Speech and Incitement, International Criminal and Humanitarian Law Perspectives, that will take place on the 18th of January. I wish all of you a very peaceful end of the year, and I hope especially that the suffering of people in Israel and Palestine, but in fact victims in conflicts around the world, will soon stop, and that they will see that the law in the end will be on their side, and that there will be accountability for the crimes committed. I think the wheels of international justice grind slowly, but they're grinding nonetheless. Thank you very much, and enjoy your evening.